Thank George and his associates for a lovely meal today. Our guest speaker today is not a guest. He is a member of the University Club, and he is going to be talking to us about his area of specialty in the law, ethics in the law. His name is Mark Cooper. Mark started out his career in law by being an undergraduate at one of America's great state universities, Indiana University, where he completed his bachelor's degree, and then he went to the University of Georgia for his law degree. He came to Orlando shortly after he finished his law degree, and he's been here ever since. He practiced law for 42 years and still found time to teach at UCF in the legal studies program for 20 of those years. And one of his specialty courses was ethics in the law. So without any further ado, because he does have so much to say, please join me in welcoming our guest speaker, Mark Cooper.
Okay, thank you. Can you hear me in the back? Yes. Anybody? I guess that's a stupid question. If you can't hear me, you don't know. I know that every good speaker is supposed to start with a joke and with a story, and I'm going to start with a story, but it's no joke. It's true, and I think that it's relevant to the topic today. As a practicing lawyer, I never practiced criminal defense work. But I had a law partner in the early 80s, late 70s, who did. And he was court appointed to represent a 22-year-old man who had been arrested after doing something that I'm going to describe carefully because we're all eating lunch. He broke into a home. He used a commonly found implement in the kitchen, and he tortured a cat and vandalized the home in a way that was disgusting and sick. He didn't have any money, and my partner was appointed by the court to represent him. What my partner discovered was that this young man was mentally handicapped, severely mentally handicapped. And when he was arrested by the police and interrogated, it would have become readily apparent to them that he was handicapped. The young man, the proposed defendant, asked if his older brother could sit in the room with him during interrogation. And the police said no. So the police did not allow him in, and while the younger brother was being interrogated, this mentally handicapped young man, he very promptly confessed to the act. It was at that point, after the confession was made, that my partner was appointed to represent him. Now, clearly what this young man had done was sick. This was somebody who was very disturbed. On television, if you were watching Law and Order or some other program of that type, you see stories where confessions are routinely thrown out by the court. And the prosecutors, the good guy prosecutors, are left to try to determine what they should do because they don't have any confession. Well, as I said, I never practiced criminal defense work, but I have a lot of friends who did and do. And one of the things that you need to know is that in the real world, confessions are almost never thrown out. It's very, very difficult to get a court to throw out a confession, but my partner did. He got the confession thrown out by the court, and the young man, there was no other evidence, and the young man was set free, presumably to go do it again, or to do some other terrible, sick thing. Here's the point. We all have the right to make a moral judgment about whether we think that action by the lawyer leading to that result was the right thing or the wrong thing. What I always used to tell my students at UCF is that if you want to learn about morals, go to the house of worship of your choice. But what we talked about in class was the law. And the rules of ethics which govern the legal profession, which are written and which I will talk about and show you in some detail, say that what my partner did was one of the finest things that a lawyer can do. He stood up. He required the state to prove its case. They were not able to prove his case, so his client was set free. And what he did, what my partner, the lawyer, did, was considered to be highly ethical and commendable, even though many people, myself included, think that it led to an immoral result. What we're going to talk about today is not morals. What we're going to talk about is ethics. And just bear in mind that, like every other kind of law, there are extensive written codes that determine what lawyers are able to do or what they're prohibited from doing. Now, so that said, the topic today is legal ethics. Jumbo shrimp, small crowd. I can say this because I was in military intelligence. Take a moment, if you will, and read what George Carlin had to say. We know what the public thinks of us. I have to tell you that in my experience, which I think is pretty extensive, most lawyers take their responsibilities, their ethical responsibilities, very, very seriously. And while there are some lawyers who do some terrible things, there are plumbers who do terrible things and doctors who do terrible things and all sorts of people who do terrible things. I don't think lawyers are any worse than anybody else, but we're a lot more visible. Let's talk for a minute about the oath that all lawyers are required to take when they become a member of the Florida Bar. And the Florida Bar, which people refer to as the Florida Bar Association, is not a voluntary group. If you are licensed to practice law in the state of Florida, you are required to be a member of the Florida Bar, and you are required to take this oath. This is only the beginning of the oath. Well, we're going to support the Constitution of the United States. We're going to honor the courts. Number three, I'm going to come back and talk about again in a minute, that we will not maintain any claim that we think is unjust or any claim that we think is not justifiable. we will abstain from all offensive personality. Now, I know a lot of lawyers in this town. That one's a little bit tough. We will maintain the confidence of our clients. We're going to talk more about that a little bit too. And finally, we will not refuse to represent anyone because of lack of money. This is the oath that we take. And this oath is enforced through an extensive body of rules called the Rules of Professional Responsibility. Now, as a lawyer, we know how we see ourselves. For those of you who don't get the joke, that's Gregory Peck and that's Atticus Finch from To Kill a Mockingbird. Okay, there are an awful lot of lawyers in my generation who became lawyers, who decided to be lawyers because of that. Now, I have not read the second book. I will not read the second book. It's going to burst my bubble, and I'm just not going there. So while this is the way we see ourselves, we know the way you see us. And somehow we just learned to live with it. So, where we are now is at the corner of law and ethics. And that's what we're going to talk about, or what I'm going to talk about for the rest of this talk. You have entered law land. And that's a joke. So please don't let that get to your head. I know I'm not a superhero. But they make jokes about us all the time, and we learn to live with that. Let's talk, though, about the rules of professional responsibility. These are the written rules that implement the oath of office that you saw a minute ago. Now, some of these, and I'm only going to talk about a few of them because there are a great many rules, but some of these are very significant. Confidentiality. There's been a lot of talk in the press lately about confidentiality and privilege, and they are not the same thing. Privilege is a communication between a lawyer and a client in a professional relationship. Anything that a client and a lawyer discuss about legal representation, with a few exceptions that I won't get into right now, is privileged. And that means the lawyer cannot disclose it, is not permitted to disclose it. It's a privilege that belongs to the client, and the client can assert, for whatever reason the client chooses, that information is not to be disclosed. I had a case many years ago where two representatives of the federal government came to my office and wanted to see my trust account records because they accused a client of mine of having stolen uncut currency from the printing facility that makes money. And they wanted to see my trust account records. Trust account is a bank account that a lawyer maintains that holds other people's money. In fact, the lawyer is not allowed to keep any of his own money in that account. Well, this was pre-computer days, so we had ledger sheets. So if you looked at a ledger sheet, it contained the records for the client that they were interested in. It also contained the records of other clients who had nothing to do with that situation. I refused to give them the ledger sheets because they were privileged. I didn't have any choice. That was the obligation. They brought me before a federal grand jury. I tried to explain to the grand jury that I could not release the records because they were privileged, And one of the jurors raised his hand and said to the prosecutor, "Does that mean he's taking the Fifth Amendment?" No, I was not accused of a crime, and no, that's the end of that story. But that's privilege. Privilege, though, is not the same thing as confidentiality. In every law firm that I've ever worked in, everything that happens in that office is confidential. It is not to be disclosed or discussed with anyone. I had a law partner who handled big money divorce cases. It was hot gossip anytime there was somebody in the waiting room waiting to see him. We had zero tolerance. It was a firing offense. If anyone from our office were to disclose to anyone outside the office who was in the waiting room or what was discussed or anything that they learned in the office, that's just the way it is. And what we tell students is, if you can't live with that, if you can't live with going home and telling your spouse at the end of the day, I can't tell you who I saw today, then you're in the wrong profession, and you need to go elsewhere. Now, there's an exception to everything. And under some circumstances, the lawyer must reveal confidential information if the lawyer reasonably believes that it will prevent a crime. Well, let's stop there. If a client comes in and tells you that they robbed a bank yesterday, past action, that's confidential, that's privileged, that cannot be disclosed to anyone. If they come in and tell you that they are going to rob a bank tomorrow, that's not privileged, and that must be disclosed to authorities. Or to prevent a death or substantial bodily harm to another person. I've had 3 instances where I was conferring with clients who, for various reasons, I was afraid were suicidal. In one of those cases, my client was involved in a hotly contested divorce case, in which I did not represent him. I didn't do criminal and I didn't do divorce. But I was representing him in other matters, and I was aware of this divorce case. And one of the significant issues in the divorce case was who was going to have custody of the children. If it became apparent that this man had suicidal tendencies, it would be very relevant in his divorce case, and it would probably lead to a ruling that he would not get custody of those children, or perhaps not even get visitation. Now, I have a conundrum. Is that the right word? Because on the one hand, everything he tells me is confidential. On the other hand, I have to disclose it if it will prevent a death or substantial bodily harm to another person. So what do I do? If I disclose it, I've destroyed his status in the divorce case. If I don't disclose it, and God forbid he really does take his life, then I have failed to meet my obligations under this rule. The Florida Bar has an ethics hotline, 800 number, that's staffed by lawyers 24/7. You can call and ask them for advice on how to handle a problem. They told me, well, if you really think he's going to do it, then you need to tell somebody. If you really don't think he's going to do it, then you can't tell anybody. That was useless. So ultimately what I did was I talked to several mental health professionals who I know, maintaining in confidence the identity of the person I was talking about. They gave me some suggestions as to, is my sound going out? Okay. They gave me some suggestions as to what to do. I followed those suggestions, and I was persuaded that he was just talking suicide. Oh, I'll kill myself. And I came to the belief that he was not seriously contemplating hurting himself, and I did not disclose it. But that's a risk. That's a risk. When students, and it's a good example of this rule, when I taught legal ethics, every student who came into that class on the first day thought this was going to be the easiest course they ever took. Because everybody knows that if it's bad, don't do it, and if it's good, it's okay to do it. And that's all you need to know for ethics. When in fact, frequently what we have to deal with is what is the best of a number of bad alternatives. And the rules can be difficult, confusing, and sometimes the guidance that we get is of questionable value. Another one of the things that we are required to do is to be candid with the court, to be honest with the court. That means that we shall not knowingly offer evidence that we know to be false. All the movies that I've ever seen and all the TV shows that I've ever seen involving criminal law have Perry Mason sitting down in the jail with his client saying to the accused, "Convince me you didn't do it." All of my friends who practice criminal defense law tell me that that is the one thing you never want to say. Because if your client tells you he did it and then wants to get on the witness stand and deny that he did it, you are committing an ethical violation if you allow that to occur. You cannot present evidence that you know to be false. You can refuse to offer evidence that you believe to be false. I was fighting a business lawsuit where there was a contract that was very, very important. And as the case was progressing, it appeared clear that we were on the losing side of this. All of a sudden, one day, my client comes in, "What do you know? I found another copy of the contract. And look, some of this language is changed in this copy." And when I looked at the contract, which was typed, it was apparent, just from looking at it, that it had been altered, that it was not the same kind of type. That, to put it politely, he had dummied up the agreement. And he wanted me to offer that contract, which, if it was believed as altered, would have meant that he would win the case. Now, I can't do that if I reasonably believe it to be false. If I reasonably believe it to be false and he insists that I offer it to the court in evidence, my ethical obligation is to ask the court for permission to withdraw from his representation. I cannot knowingly present false evidence. So the option is either I quit, which requires that you get permission from the court. So you go to the judge. You can't say to the judge or to anybody else, "My client wants to present evidence that I reasonably believe to be false," because that's privilege. That's something your client told you. So all you can do is go to the judge and say, "Judge, my client and I have irreconcilable differences, and I'd like to withdraw from his representation." Judge knows what that means. And most of the time, with that little explanation, you'll be relieved from representation. In this particular case, I was able to persuade him that his attempted forgery was so obvious that nobody would believe it, and so he abandoned that obviously falsified document, and we went forward. Another rule that has been in the press a lot is the special obligation of a prosecutor. Lawyers are advocates. We are trained and taught that our obligation is to win cases. That's not what the prosecutor's obligation is. A prosecutor cannot ethically pursue a case unless he believes that there is probable cause, more likely than not, that this defendant committed a crime. And the prosecutor is required to give to the defense any information that the prosecutor has that may tend to indicate that the defendant did not commit the crime. We call that exculpatory evidence. A lot of times when you read the newspaper and you see about criminal cases that have been reversed on appeal, they've been reversed on appeal because of what's called prosecutorial error. Usually that means that the prosecutor withheld information from the defense, and they're not allowed to do that. A regular lawyer is charged with the responsibility of trying to win within the rules of law and within these rules of ethics. A prosecutor is charged with the responsibility of doing justice. And it's not necessarily the same thing. Part of what we do, depending upon your practice, a big part of what we do is give advice to clients. Is we act as an advisor on all sorts of things that may be related to the law and may not be related to the law. In giving that advice, we are required to exercise independent professional judgment and candid advice. That means we don't have any interest that's contrary to the interest of the client. That's why some lawyers, like myself, others disagree, would never be involved in a business venture with a client. Because if you're involved in a business venture with a client, your independence may be slanted. You may have a temptation to give advice that is in your best interest rather than in the best interest of the client, and that's improper. We may, now it's interesting that most of the rules say shall, but we may, or therefore may not, in giving advice, refer not only to the law, but to other considerations such as morals. That's where we get into the morality of it. That's where we have the opportunity, but not the obligation, in talking to a client who is preparing to do something that I think is immoral, but he or she may think to be perfectly moral. I have the ability to argue with them, to reason with them, to try to persuade them. I don't have the ability to make their decision. It's the client's decision. If the client makes a decision to do something or not do something that I believe to be morally reprehensible, morally unacceptable, I then have an obligation to withdraw from the case. Because one of the things that you saw in the oath that lawyers take is we have to be zealous advocates for our client. And if I feel strongly enough that what my client is saying is wrong, that I cannot be a zealous advocate for that client, then it is my responsibility to withdraw and let some other lawyer take over. We find ourselves many lawyers find themselves an advisor a lot. And they didn't teach us that in law school. That's the sort of thing that we pick up by guess and by gosh. I've spoken with friends of mine who are mental health professionals, and we've always been bounced around the idea of writing a book for lawyers about how to deal with the psychological issues raised by something like this. Haven't done it yet, probably won't. This is a hot topic among lawyers. A lawyer shall not, again, that mandatory word, bring or defend a proceeding unless there is a basis in law and fact for doing it which is not frivolous and which includes a good faith argument to change or modify the law. In other words, if you bring a case or defend a case on a basis that a judge determines after you have done it to have been frivolous, not supported by the law or not supported by the facts, you have violated this rule. That can lead to several different consequences. By statute in the state of Florida, if it is determined that your claim or defense was frivolous, you, the lawyer, can be required to pay out of your pocket up to half of the fees incurred by the other side. Now, it's one thing if my client has to pay money. That's a shame, but that's the nature of the business that I'm in. If I have to pay the money, I look at it very closely. I'd like to think I look at it very closely anyhow. There is an issue now which is being debated by the Board of Governors of the Florida Bar as we speak, considering changing this rule, and the rule that they're thinking of adopting is saying that if a court determines that a claim or defense was frivolous, that there would be an automatic referral to a grievance committee, to a disciplinary committee, more of which I'll talk about in a little bit. That it would be an automatic, the commencement of an automatic claim which could lead to the loss of your license. Well, some lawyers think that that's, hello? Some lawyers think that that's a good idea. Some lawyers think that that's a bad idea. I think the thing just turned off. Thank you. Okay, how's that? All right. In 1954, the law of the land was that segregated schools were proper as long as the education provided was separate but equal. A lawsuit was brought against the Board of Education of the city of Topeka, and the Supreme Court of the United States unanimously determined that that law was unconstitutional, and literally just like that, the law changed. The lawyers who brought that case against the city of Topeka, the Board of Education, could have been confronted with a claim that they were filing a frivolous claim. If they had lost, if the Supreme Court had ruled against them and had said that separate but equal should remain the law of the land, it is conceivable that those lawyers could have been guilty of an ethical violation. Because you can't determine what's frivolous until after the case is over. So there is a possibility that this rule has a chilling effect, that it prohibits claims that could be made to change the law. Everybody's favorite. The Florida Bar has pages and pages and pages of rules that deal with the regulation of advertising. This is the one-sentence summary. Advertising cannot be misleading. It cannot be deceptive. The Supreme Court of the United States ruled a long time ago that lawyers have the right to advertise. Not the obligation, but the right. And the bar is still very divided over whether advertising is a good thing or a bad thing. Before an advertisement is run, the lawyer is supposed to submit that advertisement to a special office of the bar at least 20 days before the advertisement is run. And there is a committee, a staff, paid employees of the bar who review that advertising to determine whether it is deceptive or misleading. And if there is no objection, no negative statement from the bar within 15 days, they can go ahead and run the advertisement. However, if it's ultimately determined that that advertisement is deceptive or misleading, then they run the possible threat of violating this rule, which is taken seriously. Now, all of the ads that you see all over television are permitted by the Florida. I have not seen any in this state that are not permitted by the bar. When these folks say that Dan got me $1 million, he really did. Now, from that, he takes his costs and his fees. So if Dan got $1 million for them, they may have walked away with $500,000 or something less than that. But the total recovery has to be what he says it was. What the ad doesn't say is how much money some other lawyer could have gotten if they were raising the same claim. Maybe they could have gotten $2 million. You don't know that. There's no way to determine that. The public is irate about most lawyer advertising. The public is really irate when, I hope this doesn't happen to anybody, you get a traffic ticket. And you're going to start getting letters from lawyers who are going to offer to represent you. There are requirements that the bar posts that has to say in red that it's an advertisement. They have to say how they got your name, but they're allowed to contact you. What they're not allowed to do, there's a very well-known law firm in this city that's been here for, no, it's not who you think it is. There's a very well-known law firm in this city that has been here for many, many years. And the word is that the senior partner of that law firm in the 1920s used to go down to ORMC, or whatever it was called then, and he would sit in the emergency room, and as the gurneys went by, he would put his card on each gurney. You can't do that. There are a whole lot of rules about what you cannot do, but they basically boil down to you cannot mislead. You cannot intentionally mislead. Most professions in the state of Florida are regulated by agencies of the state. If you are a realtor, there is a board of professional realtors. If you're a surveyor, there's a board of professional surveyors. Lawyers are a little bit unique. We are a self-regulating body. The state has no control over us. Ultimate decisions are made by the Supreme Court, but we regulate ourselves. And this is one of the main ways that we do that. If a lawyer knows, not a lot of equivocation in the word knows, of a violation of these rules that raises a question, not just a question, a substantial question, as to the honesty, trustworthiness, or fitness of a lawyer, you must inform the bar. The cases where I've seen that happen are usually where there's somebody who has a substance abuse problem, where somebody shows up in court under the influence. You are required to report that to the bar. Nobody wants to be a snitch. But this is something that is taken seriously, and this is something that we really do. The only experience I ever personally had with this was after I tried a case many years ago, and the lawyer on the other side was just incompetent, grossly incompetent. He was clueless. He was so clueless that it was apparent that he was doing his client a gross disservice. And we won the case, not because I'm brilliant, but because he was stupid. And walking back to my office, I was debating whether or not I needed to report him. When I got back to the office, I got a call from the judge, who I knew. Orlando was a small town, everybody knew everybody. And he said, I know what you're thinking, don't worry about it, I'm reporting him. Took me out of the heat. We have a mechanism in the bar for dealing with these problems. When a complaint is filed, it is referred to the Florida Bar. When a complaint about an ethical violation of a lawyer is filed, that complaint is referred to an office of the Florida Bar that makes a preliminary determination of whether there appears to be a violation of the rules. If they determine that there's no basis to believe there's been a violation of the rules, they notify the complainant, who then has the right to seek a second opinion from the bar. If the second opinion still says there appears to be no violation of the rules, they have a third bite at the apple, and that file in its entirety is forwarded to the chair of the local grievance committee that deals with those issues. Florida is divided into judicial circuits, and each circuit has a number of committees of the Florida Bar called grievance committees, which deal with investigating and sanctioning lawyers who have been accused of ethical violations. So a complaint goes to the bar, is reviewed once, twice, then goes to the chair of the local grievance committee, and if the chair of the local grievance committee agrees that there's no ethical violation, the case is closed. If any of those three people think there is an ethical violation, then it goes to the committee. The committee is comprised of each committee is comprised of 9 people, 6 of whom are lawyers, 3 of whom are non-lawyers. No one can serve for more than a 3-year term on the committee. And the responsibility of the committee is to determine whether there is any probable cause to believe that there has been a violation of the rules of professional conduct, only a few of which I have listed for you here. The way that's done is that members of the committee are given the responsibility of investigating that particular claim, and that's what they do. They will telephone, they will meet with the various people who are involved, they can take sworn statements, they can do whatever they need to do, they have subpoena power, and to try to determine whether there is a reasonable basis to believe there's been a violation of the rules. They then have the right to recommend any one of a number of sanctions, from a private reprimand, which means a letter goes to the lawyer but nobody sees it, it's not a matter of public record, nobody knows. And it can go all the way up to disbarment, which means you lose your license. If the offending lawyer does not agree with the recommendation of the committee, the offending lawyer has the right to a trial. And a judge will be appointed to conduct a trial to determine whether there has been a violation of the rules. The judge will make a recommendation of guilt or non-guilt, and penalty or non-penalty, and then that will all go to the Supreme Court of the state of Florida, which makes the ultimate decision about whether or not there is guilt, and if there is guilt, what the penalty should be. In the current atmosphere for the last 4 or 5 years, and I don't know why this is, the Supreme Court has been on a tear. And they get recommendations that such and such a lawyer should be suspended from the practice of law for 1 year. And the court is consistently coming back and saying, no, this was too serious, he's disbarred. The most recent statistics that we have are here. The total number of lawyers licensed to practice law in Florida is 100, as of the end of 2017, is 104,676. They don't all live here. There are lawyers who live in other states who have the right to practice law here, maybe because they want to retire here later on or whatever. But most of those lawyers live in the state of Florida. Last year, in that calendar year, 46 lawyers were disbarred. 179 lawyers were suspended. There's different kinds of suspension. If you are suspended for less than 90 days, if you are suspended at all, you are required to send a letter to each of your clients telling them that you have been suspended for a period of time, whatever the period is. And you cannot do any legal work during that period of time. You have to file an affidavit with the Supreme Court confirming that you have sent that letter to all of your clients. If you don't do that, if you don't file the affidavit, which is not an uncommon occurrence, you will be disbarred. In fact, when you are first approached by the grievance committee and you are told that there's a claim against you, if you refuse to respond to the grievance committee, you may very well be disbarred. The worst day in any lawyer's life is the day he gets a letter from the grievance committee saying, we're investigating you. Suspensions, if you're suspended for more than 90 days, then once your suspension is over, you have to take the bar exam again. And nobody in his right mind would want to do that. It is an emotional, a mental, a physical ordeal, but that's the rule. A public reprimand is the kind that you see in the newspaper. The Supreme Court announces its disciplinary decisions every month on the last day of the month. They issue a press statement. And the newspapers all look through those, and if there are any local lawyers, they'll publish, they'll print what the bar has said. If it's a public reprimand, then presumably you have done something that's bad. It's not awful, but it's bad, and your wrist is slapped in public, and frequently you will be required to go to Tallahassee to appear in person in front of the Supreme Court so that they can chew you out, which I'm told is the kind of thing that nobody in his right mind would want to experience. A disciplinary revocation is essentially the same thing as a disbarment. But it happens when the lawyer says, I don't even want to fight this thing. I give up. Here's my license. I'll go pump gas or do something else. An admonishment is simply that. It's a statement that you have not violated a serious rule, but we call it a letter of advice. But here's what you've done, and you would be well advised to change whatever the practice was that you were doing, and so you won't do it again, so you won't get into any trouble. And finally, there are probations, which are exactly what the word implies to everyone. To my knowledge, we're the only profession that has a system like this that self-regulates. I meant to look today at the latest figures to see what percentage of our bar dues goes towards maintaining this system, and I forgot to do it. And it changes each year, but I believe, and this may be wrong, that it's about 30% of the money we pay for bar dues goes towards funding this disciplinary system. If you file a complaint against a lawyer with the Florida Bar, that costs you nothing. You incur no expense, no cost. You will have to devote some time to answering questions and being interviewed, but there is no expense to you at all. The bar takes seriously its obligation to self-regulate. And to make it even easier, there is a hotline that you can call that we call ACAP. If you believe that you have been aggrieved by a lawyer, if you believe that a lawyer has violated the rules of ethics with you, and it doesn't even have to be your own lawyer, it can be, under some circumstances, it can be another lawyer, then you can call this number and they will guide you through the process. You will have to submit a complaint in writing. They will not act solely on an oral complaint, but they'll help you fill it out. They'll help you go through the process so that the public can feel comfortable and confident that when they have a lawyer, if they have a lawyer, that their lawyer is looking out for them and for nobody else. That their lawyer doesn't have an axe to grind against them, that their lawyer will be their advocate within the law and within the rules. And I have to tell you, with all of the jokes aside about legal ethics being an oxymoron, and I guarantee you I know more of those jokes than you do. Lawyers take their ethics very, very seriously. This is the essence of what we do. We're proud of it. And we want the public to know that we really are trying to meet our obligations, to meet our responsibilities to you, the members of the public who rely upon us. Thank you very much. I don't know how long I've been talking. Do we have any questions?
Thank you, Mark. That was such an excellent presentation. Of the discipline committee, you said 6 were attorneys and 3 were, what were the other 3?
They could be any profession, as long as they are not lawyers. So we have, during the time that I served on a committee, we had a police officer, we had an accountant. We like to get accountants there because a lot of the issues that we deal with are financial issues, and it's helpful if we have somebody who's got a financial training. They can be anything. Obviously, there's a check made, there's an investigation made to see that we're not putting anybody on the committee that's who has less than a good record. We don't want any crooks on the committee.
Mark, since lawyers generally bill by the hour, are there any rules that say they have to report to the client weekly or monthly or in some period how much money is being spent that they're going to have to pay the lawyer at some point?
There are a lot of rules. That's a good question. There are a lot of rules that relate to fees. The most important one is that a lawyer is not allowed to charge an excessive fee. That depends on the circumstances, depends on what the case is. There are other rules that say that a lawyer has a responsibility to always keep the client informed about what the case is about. Actually, a lot of the complaints that are made in the disciplinary system are complaints where the lawyer is just not communicating with the client, doesn't know what's going on. I'm not aware of any rule that says that you have to report periodically about the fees, but there are rules that suggest, well, in certain kinds of cases, if you're going to a personal injury lawyer and he's going to represent you on a contingent fee, so his fee is a percentage of the recovery, that agreement has to be in writing. It has to be reasonable. There's a cap to a maximum of what the fee can be, and a client, if there is a dispute as to fees, which obviously occurs with some frequency, the bar has a system of fee arbitration and fee mediation, where the lawyer and the client can go to impartial third parties and have them try to resolve the disagreement. Most lawyers, and this is not a rule, but most lawyers will tell you that the best way to avoid this problem is to first have a very clear understanding from the very beginning of what the fee will be, what the basis of the fee will be, when bills will, if it's an hourly fee, when bills will be submitted, that those bills should be detailed. They should set forth what it was that was done and how long it took. And that the lawyer should always be open to questions. If there's some doubt as to whether something was done or the time that was taken, then you have the right to ask your lawyer for clarification. The important thing is the lawyer's not running the case, the client is. The client's the boss, not the lawyer. So the client has the right to do a lot of things like get clarification on things like that. Does that answer your question?
I believe you said the grievance committee was somewhat unique to the Bar Association, but isn't it similar to the internal affairs of the police department or the inspector general of the Justice Department?
Well, in a way it is, but they can't take away your license. They can't take away, if you're a police officer, and I think, I'm not certain of this, and you're disciplined by your office, you can lose your job, you can lose your pension, but you can also go somewhere else if you can get the job and work as a police officer. If you're a lawyer and you lose your license, you're not gonna get a license from any other jurisdiction. You're out.
Of this state?
Well, each state has a separate rule, a separate association or separate admission. But when you apply to a state, one of the things you have to state under oath is whether you've ever been disciplined by the bar of any other state, and if so, why. And I have to tell you, the bar, when you apply for membership in the bar, they run a pretty thorough background investigation. I applied for the bar 3 years after I got out of the Army. And the bar was more thorough in their investigation of me than the Army was for my security clearance. I didn't have a real high security clearance, but still,
Mark,
what they did was quite thorough.
Mark, thank you. I have a question again which relates to that. I presume, and I understand correctly, other states have similar associations, bar associations.
Yes.
Are the rules approximately the same? Because the statistics, I mean, having, if I counted correctly, about 0.03% of the lawyers have some ethical problems, while the rest don't. Seems to be a very ethical community. Do the other bar associations have the same rules? And what are the figures there? And I have a second question. Can you differentiate for me, not being having English as a mother tongue? I always thought shall is a weaker command to do something than must. And you equated them both. Shall and must is the same thing.
Let me answer your first question first. I don't know what the statistics are in other states. Every state has rules regulating lawyer conduct. I'm sure that they are not all identical, but they are very, very similar. There is a model code adopted by the American Bar Association, and most of the states have rules that are very similar to that. So Florida is the only bar that I'm a member of, so I really don't know what the statistics are in the other states. Your second question was? Oh. Well, there may be people who disagree with me, but in my mind, shall and must are pretty equivalent. That means it's mandatory. Whereas may means that there's some volition involved in the action. When the rule says you shall do something, that means you have no choice. If you must do something, you have no choice. If you may do something, it's voluntary.
if the glove don't fit, you must acquit. Now, that sounds frivolous to me, but it's clever, it's easy to remember, and it seemed to have trumped the evidence on the other side, including blood samples. What's going on there?
There is a principle called jury nullification, where, and it's an improper argument for a lawyer to make, but it's done all the time, where what the lawyer will in essence argue is, forget all the evidence, under whatever circumstances I'm telling you, this person should not be convicted. That's called jury nullification. You're not supposed to do it. If you really want to understand the system, first thing you need to do is disregard everything you see on TV and the movies. None of that stuff is real. It's not the way the system works. If I walked into a courtroom and made some obnoxious, offensive question to the witness and then immediately said, "Oh, withdrawn," I'd be in a heap of trouble. They do that on TV all the time. You can't do that. In the real world, trials are pretty dull. There's not that many where there's a smoking gun. The Johnny Cochran, who made that argument, was famous for his courtroom theatrics, and there are a lot of lawyers who do that sort of thing. But his argument, as I recall, essentially was that this glove was a crucial piece of evidence, and if it didn't fit, you'd need to acquit. Well, if the jury agrees with that, then he's right. So I don't think that that's necessarily a frivolous argument. I mean, we can all disagree about the outcome of the O.J. case. I don't remember it well enough to want to go there. But the system is about persuasion. In our system, we have a jury in the state of Florida in a criminal case. Unless it's a capital offense where someone could be sentenced to death, we have a 6-person jury. And the way if it's a capital case, there's 12 people in the jury. And the way the system works is we pick the 12 people who don't know anything about it. Or what some cynics would tell you is we pick the 12 people who were too stupid to know how to get out of jury duty. I don't buy that theory, but that's what some people will say. So you have people who know nothing about the case, and the lawyer's job is to persuade them one way or another. And as long as you do that within the law and within the rules of ethics, that's your job. Is a lot of it theater? Yeah. But there are strict rules that regulate what we can do and what we can't do, and most lawyers follow those rules, or at least really try to.
Final question.
Okay?
In regard to Ms. Ayala, who is the state attorney, she, during her campaign, said nothing about prosecuting capital offenses. It was later revealed that she was not going to prosecute for the death penalty. Why wasn't she reprimanded? Maybe she was, but I don't remember reading anything about her being reprimanded for misleading the voters. Isn't that important to the bar of the state of Florida?
It's not a violation of the rules of the bar to mislead the voters. It's a violation to mislead in advertising. I think she was reprimanded by the governor, and I suspect that when re-election time comes around, she's going to face this issue again. But ultimately, under our system, it's going to be the voters who decide whether she should be punished or not, and the punishment would be to vote against her.
Mark, there are many questions still wanting to be asked, but we've reached the end of our time. Will you stick around for a little while if anybody wants to talk to you? Thank you very much for your question.
Thank you all.